Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on today's session. In today's session, we're continuing with our ongoing series entitled Recurring Themes in the QME Evaluation. And this is the second of our recurring themes. Today I want to talk to you about one of the most common situations that you'll ever encounter in your QME practice. And you will encounter this over and over and over again. Probably 7 out of your next 10 cases will involve this recurring theme. Today's theme has to do with the unwitnessed incident that involves a delay in reporting of that incident of industrial injury. Now, before we get into today's discussion, let's just review the philosophy of this series and talk very briefly about our last session. In this session entitled Recurring Themes in the QME Evaluation, we're talking about the difficult cases that you will get. Now, typically these difficult cases involve denied claims. And what is it about these cases that makes them difficult cases? It makes them difficult because the opinion for or against industrial causation, in other words, AOE, COE, is not clear. Now, in easy cases, this is the difference between difficult and easy cases. In easy cases, AOE, COE, industrial causation, is never disputed. It's a very easy case to handle when you have an injured worker who had a witnessed incident, who had bona fide orthopedic or other types of injuries, received immediate medical care, and had an incident that was witnessed by the owner of the company, by his supervisor, and by 2 or 3 co-workers. These are the easy types of cases for which the claims administrator readily accepts the claim, readily provides medical treatment, and the case continues until the examinee or the injured worker is permanent and stationary. Those are the easy cases. We're talking in this series about the difficult cases where AOE, COE is in dispute, and these typically come to us as denied claims. Now, why do these cases come to us as denied claims? Well, Labor Code 3600 tells us that the burden for establishing an industrial injury, the burden of proof for establishing industrial injury, lies with the applicant. It lies with the examinee. The injured worker employee, by law, is required to prove with a preponderance of the evidence, is the language found in Labor Code 3600, with a preponderance of the evidence, they are required to prove their industrial injury. And in those cases where the claims administrator gets a hint that the examinee cannot prove with a preponderance of evidence the occurrence of an industrial injury, they simply deny the claim because they know the examinee cannot prove the claim. Well, one of the red flags for an industrial injury that we talked about in our last session has to do with job dissatisfaction. And many of the examinees that you're going to see in your career will express to you at some point, or at many points, or at all points throughout your face-to-face interview with them, they will express some form of job dissatisfaction. And you'll get a sense that you're dealing with an examinee that has some sort of disgruntlement, some sort of a beef, some sort of a conflict, some sort of friction with their job. Typically, this involves friction with their immediate supervisor. And we learned in our last session that examinees who have job dissatisfaction, let me rephrase that. Employees who have job dissatisfaction, in other words, they score lowly on job satisfaction scales, okay, file claims for industrial injury at 2 times the incidence that employees with high job satisfaction scores file claims. Employees who have job dissatisfaction who file claims have twice the duration of disability as examinees who file claims who are satisfied with their job. And third, employees who have job dissatisfaction who file claims for industrial injury have many times the overall cost of the claim, not just double, not just triple, many fold increase, many times the cost of overall claim as employees who file claims who are satisfied with their jobs. What is the takeaway message from these studies and these statistics? Well, out of your next 3 examinees, 2 of them are going to be examinees who have job dissatisfaction. Examinees who have job dissatisfaction have a difficult time getting well. They delay getting well. They fail to recover to pre-injury status. They have twice the disability, twice or more, the disability duration as examinees who are satisfied with their job. Examinees who have job dissatisfaction have many fold increase in the overall cost of the claim because they refuse to get well, they refuse to go back to work, they stay on total temporary disability for extended periods because they don't want to go back to a job that they're dissatisfied with. So the next time you're with your examinee and you pick up hints of job dissatisfaction, you know that you're dealing with an examinee who is going to have a difficult time getting well, is going to have an overall high cost of the claim. And so this is important information for you when it comes time to render your critical decision on AOE, COE, for or against industrial causation. So job dissatisfaction is one of the major red flags for workers' compensation fraud in the first place and for difficult claims in the second place. Difficult, protracted, and costly claims in the second place. Now today, I want to talk to you about probably the most common recurring red flag that you'll ever encounter for workers' compensation injury, and that has to do with the unwitnessed incident with a delay in reporting. Now, witnessed incidences that are reported immediately are not a problem. Can you see the contrast between these two scenarios? When you have an injury incident that's witnessed by supervisors, managers, owners, co-workers, that's reported immediately, there's never a question as to whether or not this qualifies as an industrial injury or not, because it was witnessed and it was reported immediately, and the examinee has bona fide diagnosable conditions that rise to the level of an industrial injury. Those are easy cases. The flip side of that is the incident that involves an unwitnessed incident with a delay in reporting. Now, the typical scenario where these two red flags play out involves an examinee who comes to work on Monday morning, and he confronts his supervisor by telling the supervisor that last Friday, 3 days ago, before the weekend, last Friday, while they were working alone in the warehouse, they were unloading the shipment of boxes, and while moving some boxes, they suffered an injury to the lower back. They didn't think much of it at the time. They thought it would go away, so they didn't report it. But over the weekend, don't you know, the pain worsened, and so by Monday morning, they realized that they must report this as an industrial injury. It was an unwitnessed incident with a delay in reporting. Now, you're going to see all types of delay in reporting. What qualifies as a delay in reporting? Well, anything less than immediate reporting is a delay in reporting. And if you're familiar with safety meetings and corporate safety procedures, you'll agree that many companies have a policy that if there's an industrial injury, no matter how small, if you even stub your toe or break a fingernail, they'll tell you in safety meetings, report the injury immediately. Report the injury immediately. This is a policy with many companies to report the incident immediately. So anything less than immediate is a delay in reporting. And there can be an overnight delay in reporting. There can be over the weekend delay in reporting. There can be delays in reporting for weeks. There can be delays in reporting for months. There can be delays in reporting for years. And the further in time the report of the incident is displaced from the alleged occurrence of the incident, the less credible is the claim for an industrial injury. And these are the circumstances where the claims administrator simply gets out the denied stamp and puts a denial on the claim because they know the examinee cannot prove, has no way to prove, it's impossible to prove by a preponderance of the evidence that an industrial injury occurred. So they simply bring out the denial stamp. Now, in these cases of a denied claim, the law allows the examinee to pursue a QME evaluation. What's the purpose of the QME evaluation in the case of a denied claim? Well, the purpose of the QME evaluation is for the examinee to try and convince you, the evaluator. See, this is how they attempt to prove it, by a preponderance of the evidence. They attempt to prove it by trying to convince you, as a qualified medical evaluator, that the incident of injury and the injury actually occurred. So the law allows them a QME evaluation. The law allows a QME evaluation even when the claim is denied on a non-medical basis. Now, let me give you an example. There's many reasons for a claims administrator to deny an industrial injury. The most common are administrative reasons, non-medical administrative reasons. So let me give you an example of an administrative denial. Guy comes into his supervisor on Monday morning and says to the supervisor, on Saturday, when I was at the company picnic, I sprained my ankle while playing in the softball game. And sure enough, the supervisor looks down at the employee's ankle, and the ankle is swollen, the employee is limping, can barely walk, and appears to have bona fide pathology of the ankle. But the supervisor scans his memory and recollects that on Saturday at the company picnic, this particular employee did not attend the company picnic. So the supervisor responds by saying, I was at the company picnic. I played in the softball game. You weren't at the softball game. What are you trying to tell me? You sprained your ankle at the softball game. You weren't even at the softball game. And this is a claim that's denied administratively because the employee wasn't even at the softball game. It's not denied medically, it's denied administratively. Now, the law provides for a QME examination for the employee to attempt to convince you as the doctor that this incident of injury actually occurred when it's denied administratively. So in this case, when the examinee comes to you, he may have evidence of bona fide pathology of the ankle. He has a bona fide sprained ankle. The issue is not a dispute over whether or not there's a sprained ankle. The issue is a dispute over whether the injury occurred in the course of employment. It's an AOE, COE dispute. And these are simply denied administratively. So we're going to talk about the role of the qualified medical evaluator in these cases where the case is denied, sometimes administratively, sometimes medically. What's the role of the qualified medical evaluator? If the case is denied administratively because the employee wasn't even at the company picnic, does it even matter what you as the qualified medical evaluator say in terms of your AOE, COE opinion? Does it even matter if you opine for FOR, industrial injury? Does it matter if the employee was not actually at the softball game? No, it doesn't even matter on these denials, these administrative denials. So we're going to talk about the role of the qualified medical evaluator in these denied cases that involved an unwitnessed incident with a delay in reporting. And this is a scenario that you're going to see recurring over and over and over, and you've probably already seen dozens and maybe even hundreds of these cases. So I have a fascinating program for you. It's probably going to relate to your very next examinee. So I want to assemble some materials, and I look forward to being back with you here in just a couple of minutes as we continue our ongoing series entitled Recurring Themes in the QME Evaluation. And today we're focused on the unwitnessed incident with a delay in reporting. Okay, I'm back with you now, and we're talking about the unique circumstance of an unwitnessed incident with a delay in reporting. And we talked about a delay in reporting. A delay in reporting can be anything less than immediate reporting. And I want you to imagine that you're at home, and it's a Saturday. And one day on a Saturday, you get a knock at your door, and you go to answer the door, and you recognize the person at the door as a gutter and roof repair person who you had out to your house approximately 30 days ago to do some repair on your roof. So because you recognize this person, you open the door, you greet them, and you ask them what is the purpose of their call to your house today. And the repair person proceeds to tell you that when they were at your house approximately 30 days ago, they suffered an injury at your house. Now, they didn't tell you about it at the time because whatever reason, they didn't think much of it. They thought it would probably go away. Whatever, fill in the blank as to the reason why they didn't report it at the time. But they're now coming back 30 days later to report that some symptoms that they're having today are due or were caused by an incident that occurred while they were working on your roof approximately 30 days ago. So we have a 30-day gap, a 30-day delay in reporting an injury. Well, as time goes on between the alleged date of injury and the date of reporting, as that gap increases, there's what's called a loss of temporal relationship. Loss of temporal relationship. Temporal means related in time. Comes from words like temporary, is related to time. So there's a loss of temporal relationship between the symptoms that the examinee reports to you 30 days later and an incident of injury alleged to have occurred 30 days earlier. There's a loss of temporal relationship. I mean, think about it. A lot of things transpire in 30 days. This worker has probably worked on a couple dozen other houses. He's done a dozen projects around his own house. He probably plays on some after-work sports leagues such as softball or hockey or volleyball or something like that. Probably has other hobbies. And so it becomes increasingly difficult when there's a loss of temporal relationship between the alleged incident and the symptoms that the examinee reports. So many of these examinees that you're going to see are going to be telling you about symptoms that have a loss of temporal relationship to any incident that may or may not have occurred at work. And these come to us as denied claims. So when you get these denied claims that involve an unwitnessed incident with a delay in reporting, the occurrence or non-occurrence, meaning whether it happened or it didn't happen, the occurrence or the non-occurrence of an industrial injury is not a medical determination. We don't need a medical expert like you to resolve this dispute. The dispute and the occurrence or non-occurrence of an industrial injury is a question of fact. Did it occur? Did it not occur? We don't know. We weren't there. It's not a medical determination. It's a question of fact. Now, who resolves the questions of fact in workers' compensation disputes? Questions of fact are resolved by the trier of fact, which is the judge. We as qualified medical evaluators do not resolve questions of fact. We resolve questions of medical disputes. And many qualified medical evaluators want to step outside of medical determinations and want to opine about questions of fact. Now remember, Labor Code 3600 requires that the examinee prove by a preponderance of the evidence that the injury is industrial. The burden is upon the injured worker. The burden is not upon the evaluating doctor, and many times the evaluating doctor unnecessarily assumes the examinee's burden. And I'm here to tell you to don't do this. Do not assume the examinee's burden. The examinee's burden is the examinee's burden. It's their requirement by law to prove by a preponderance of evidence that an industrial injury occurred. So when we get these cases and we're face to face with an examinee who's reporting an unwitnessed incident with a delay in reporting, and there's a loss of temporal relationship, what is the role of the qualified medical evaluator? What is your role? Let me just pause for a second and let you ponder that question. What is your role? Well, in these cases, your role is quite simple. Your role is to determine, number one, does the examinee have bona fide pathology? Do they have a bona fide diagnosable condition that rises to the level of an injury? And remember, an injury is defined as causing a loss of time from work and or a need for medical treatment. And sometimes to qualify as an injury, we need to see the presence of both of those coexisting. There has to be lost time from work and need for medical treatment. We can think of it as an injury as causing one or the other, or one and the other. Lost time from work, or a need for medical treatment, or lost time from work and need for medical treatment. So that's our first obligation. Does the examinee have a bona fide diagnosable condition that rises to the level of an industrial injury? In other words, is there pathology? Now, you will frequently, if not always, find pathology in the examinee. Examinees have pathology. They come to us with pathology. Don't be confused by pathology. They're going to present with pathology. The dispute is not over the presence or absence of pathology. The dispute is over the presence or absence of industrial injury. But our first obligation is to determine, do they actually have a diagnosable condition consistent with their complaint of symptoms? That's a medical determination. Okay? Our second obligation is, if we discover bona fide pathology, a bona fide diagnosable condition, is it possible? And even stronger than that, is it probable? Is it reasonably medically probable, 51%, that bona fide pathology could have been caused by an injury incident to have occurred in the manner that the way they described it to have occurred? So let me say that again. What is the role of the qualified medical evaluator in these denied cases that involve unwitnessed incident with a delay in reporting? Okay? Remember, the occurrence or non-occurrence of an injury is a question of fact. So what's our role? Well, our role is to opine on medical issues as those medical issues relate to causation. So number one, does the examinee have a bona fide diagnosable condition that rises to the level of an industrial injury, that rises to the level of an injury? If so, then number two, is it reasonably medically probable that that condition could have arisen from an incident of injury that occurred to have occurred in the manner in which the examinee described it to have occurred? If both of those coexist, and both of those are affirmative, then you can excuse me, then you can opine for industrial injury. If you don't find bona fide condition, that's the best way to deny a claim, is to find, I don't find any condition. Examinee comes in reporting lower back pain. I don't find any diagnosable condition that rises to a level of an industrial injury, and you can easily deny that claim. But let's say you do find bona fide pathology of the lumbar spine. Is it possible that that pathology could be due to an incident of injury to have occurred in the manner described by the examinee, the way he described it to have occurred? Is it reasonably medically probable? When both of those are in the affirmative, then you can opine for industrial injury. Now, again, we said that the law allows the examinee the opportunity for a qualified medical evaluation as part of their attempt to prove an industrial injury. So in cases that are denied non-administratively, like the softball example in the company picnic, many times we have examinees that report industrial injury with an unwitnessed incident with a delay in reporting that actually suffered an industrial injury. There's many reasons why an injury could be unwitnessed, one of which is many employees work alone, either in the field or at their particular job site. There are no witnesses around. So just because an injury was unwitnessed doesn't mean it did not occur. So we're going to see examinees that have unwitnessed incidences with a delay in reporting where an injury incident actually occurred, but the claim is denied. So the examinee comes to us to convince us to provide an opinion for industrial causation, and they do that by their testimony. Now, we know that examinees have differing motives in their testimony. We know that we have examinees that are truth tellers, and we have examinees who may not be truthful all the time, if you know what I mean. Examinees have varying motives for filing claim for industrial injury. So what I want to share with you now are some interviewing philosophies and some interviewing strategies to very quickly get to a determination as to the credibility of your particular examinee. So this has to do with your face-to-face interviewing techniques with an examinee that has a denied claim that involved an unwitnessed injury with a delay in reporting. Okay? Now you're going to find this to be quite fascinating. And this is a novel application of some existing interviewing philosophies that are already being used in criminal and forensic settings and increasingly being applied into insurance claim settings. Insurance claim settings. In other words, there's insurance claims of all different types being filed in every state of the union as we speak, not all of which are legitimate. And claims administrators and managers need to use techniques to quickly sort out the legitimate claims from the fraudulent claims, and so do we as qualified medical evaluators. And so there are some new approaches being applied to the insurance claim setting, and I want to share several of those with you today. So let me just read for you a couple of key concepts, okay? And I'll share with you the studies from which these ideas come. And I have them all here for us, okay? Now, in legal, criminal, forensic, and now in insurance claim interviewing settings, truth tellers and liars can be distinguished by the amount of rich and verifiable detail that they offer. The gap between the two is magnified when the interviewer tells the interviewee in advance that they plan to verify all details to assess for credibility. This causes the truth tellers to pour on even more details, while the liars struggle because they cannot come up with details that can be verified. That is, without bluffing. Now, when you're with your examinee, and your examinee is telling you about the mechanism of injury and what happened after the injury and all of the sequence of events that contributed to the injury, you're going to be paying attention for two things. Number one is richness of detail. Richness of detail. Truth tellers provide rich detail. Why do truth tellers provide rich detail? Because it's very easy for them to recall the detail, because the detail truthfully happened. Liars, on the other hand, have to go through cognitive processes, conscious cognitive processes, to produce their story. And one of the lacking sources of information, one of the lacking pieces of information that liars are unable to construe is the rich detail. Now, specifically, the difference between truth tellers and liars is that truth tellers provide rich detail that can be verified. A liar, in fact, a good liar, can provide rich detail, but they provide rich detail that cannot be verified. The difference between truth tellers and liars, you'll find in your face-to-face evaluations, is that truth tellers provide rich detail that can be verified, whereas liars provide details, not always rich, which cannot be verified. And let me share with you some studies into this subject. So this comes from criminal and forensic settings now being applied to the insurance claims settings. So I just want to share with you a couple of studies here on this. This first one is published in the Journal of Legal and Criminological Psychology. This is a 2014 study, and it's entitled Exploiting Liars' Verbal Strategies by Examining the Verifiability of Details. As I said, both truth tellers and liars will provide details. Truth tellers will provide rich detail which can be verified. It's verifiable. Liars provide details that cannot be verified. And how many times have you sat across from an examinee and you ask the examinee, well, did you file an incident report? The examinee will say something like, well, I gave my boss a note. I put a post-it note on my boss's desk. I put a post-it note on my boss's desk. A completely unverifiable detail. It's not able to be verified. Okay? So, a couple key concepts. The purpose of this study is to examine the hypothesis that liars will report their activities strategically and will, if possible, avoid mentioning details that can be verified by the investigator. So you'll notice that examinees who are attempting to fabricate an industrial injury will provide details that cannot be verified. The reason they provide details that cannot be verified is because they're afraid that the evaluator will verify the details and will find them to be not credible. So they leave out the details that can be verified. Isn't that fascinating? Isn't that fascinating? Okay, so let me just read a couple concepts for you and allow you to think about how you can implement these into your interviewing techniques with your very next examinee. And I'm just going to read a couple key lines from this study. Distinguishing truth from lies is a difficult task. Reviews of more than 100 deception experiments have shown that nonverbal and verbal cues to deceit are typically faint and unreliable. One explanation as to why cues to deceit are faint and unreliable is that liars cannot take their credibility for granted and therefore attempt to make an honest impression. See, when you're telling the truth, you're not concerned about making an honest impression. You're simply telling what happened. Liars, on the other hand, attempt to make an honest impression. There's a cognitive process in place with the storytelling of liars. That is, liars control their behavior and speech and attempt to display behaviors and say things that they believe give an honest impression and avoid behaviors and speech that they believe raise suspicion. Okay? So they leave out the details that would raise suspicion. Now, awareness of liars' motivation to control their behavior and speech may uncover the differences between liars and truth tellers and could benefit us in the detection of lies. Liars may attempt to avoid saying things that they think will sound suspicious, yet this avoidance may give the lie away. Interesting. Liars will be more concerned than truth tellers with impression management. Therefore, compared with truth tellers, liars are more keen to construct a report which they believe will make a credible impression on others and will leave out information which they think will damage their image of being a sincere person. And the information that they leave out are the details which are easily verified. Do you follow? So liars' stories are devoid of details which could be verified. Now let's contrast this with the story of a truth teller. Truth teller provides rich detail, all of which, most of which, a large percentage of which could be easily identified or verified. So a truth teller will say, yes, I did. I filed an incident report. We keep our incident reports in the top filing cabinet in the manager's office. It's the third file back. I know right where they are. I grabbed an incident report. I filled it out. I kept my pink copy, and I left the yellow copy on the desk of my supervisor. I signed it, I dated it, I left it on the desk of my supervisor. And here is my pink copy. And the examinee verifies the details either themselves or makes it easy for you to be able to verify the details. Truth teller will say something like, yes, I left a post-it note on my boss's desk. He was not yet in at work, but I left it right on his desk where he would immediately see it. And there's absolutely no way to be able to verify this particular detail. So a liar's strategy involves avoiding mentioning details that can be verified. Liars, no, this is listeners. This is about us as listeners. Listeners use content qualities to distinguish between truth and lies. And indeed, one of the verbal criteria observers say they rely most upon when detecting lies is richness of detail. The richer an account is perceived to be in detail, the more likely it is to be believed. Have you ever had an examinee who you felt was a poor historian? They were unable to elaborate on the details of what happened. You'll ask them, tell me how you injured yourself. And they'll give you a vague description. Not rich in detail, but poor in detail. And you'll probe them for more detail, and they're unable to provide detail. Sometimes we refer to these people as poor historians, and I'm sure you're familiar with this type of an examinee. So richness of detail. Now, this richness detail puts liars in a bit of a dilemma. On one hand, they are motivated to include many details so that they make an honest impression, but on the other hand, they're motivated to avoid providing details to minimize the chances of being caught. So it seems that liars are in a bit of an information management dilemma. They want to provide details so that they appear credible and believable, but they don't want to provide too many details because they don't want to provide any details that can be easily verified, because that would expose them as liars. So they're caught in this information management dilemma, which you as the qualified medical evaluator can quickly discern, can quickly observe, and can quickly conclude that none of these details are verifiable, which will assist you in your opinion for or against industrial injury. Now, in building upon this verifiability approach, the verifiability of richness of detail, it's found that this method of interviewing is made even more powerful by letting the examinee know in advance that their details will be subject to verification. That every detail that they give you, you're going to attempt to verify through the medical records, through the historic records, through the administrative records. In other words, you're going to be going through all of the medical records and the x-rays and the diagnostic studies to verify the details that they tell you. And let me just read to you the outcome of studies that use this prompting or informing the examinee in advance that their details will be verified. Liars tend to, this is from a study published in Applied Cognitive Psychology, 2014 study in the journal Applied Cognitive Psychology, entitled The Verifiability Approach. Countermeasures facilitate its ability to discriminate between truth and lies. According to the verifiability approach, liars tend to provide details that cannot be checked by the investigator, and awareness of this increases the investigator's ability to detect lies. In the present experiment, we collected written statements from 44 mock liars and 44 truth tellers, where half of them were told before writing their statements that the verifiability of their statements will be checked. So they notified the participants in this study that whatever details you provide us in your written statement of a mock scenario, we're going to check those details. We're going to verify these details. You let them know this in advance. The results showed that this informing encouraged the truth tellers, but not the liars, to provide more verifiable details and increase the ability to detect lies. So when you tell the examinee in advance that you're going to be checking all the details that they provide you, the truth tellers pour on the details. They pour on the details. They let you have it. They unload both barrels of details because they know they have no fear that those details could be verified. But liars will come up short because they know that they don't have an abundance of details that can be verified. So while they may provide rich detail, the rich detail is full of details, none of which can be verified. And isn't that consistent with the denial of the case? These are cases that the claims administrator denies because they know that the examinee has no way to be able to verify their industrial injury. And these are cases that, more likely than not, are incidences that actually never happened. These are cases that are red flag cases that you can comfortably, confidently, and within reasonable medical probability deny as AOE, COE as not qualifying for an industrial injury. Okay? And there's several other studies involved with the verifiability approach. And the point of it is that we're going to get denied cases. We're going to get denied cases that involve unwitnessed incidences with a delay in reporting. Now, some of these incidences involve actual injuries that actually occurred. And in those cases, in the case of an actual injury, we want to opine correctly for FOR, industrial causation. We don't want to make an incorrect determination on AOA COE. So in the presence of a bona fide injury, we want to opine correctly. In the absence of a bona fide injury, we also want to opine correctly. We don't want to opine for an industrial injury for an incident that never actually occurred. So in many cases, the opinion for or against industrial causation comes down to the credibility of our examinee. And the credibility of our examinee can be quickly assessed in the face-to-face interview by the richness of detail that the examinee provides to us in response to our interviewing questions. Truth tellers will provide rich detail, rich, vivid detail. They'll tell you exactly where the claim form was found, who signed it, what date, where they put it, here's their copy, when they went to the doctor, what the doctor said, what the doctor did. They'll provide rich detail, most of which can be verified. The liars, those attempting to fabricate an industrial injury for whatever reason, attempting to fraudulate an industrial injury for whatever reason, will be unable to provide rich detail and will be unable to provide verifiable detail because those details never occurred. And they leave those details out of their testimony out of fear that you as the qualified medical evaluator will check the details, will attempt to verify the details, and will find them wanting or lacking. Now, what is it called when an examinee provides to you rich detail, verifiable detail, that is verified to be false? In other words, they provide to you rich detail, they challenge you to verify the detail, you verify the detail and find them to be a liar. That's what's called bluffing. And examinees will sometimes resort to bluffing in an attempt to convince you of the credibility of their statement. So if you advise the examinee that you're going to check the verifiability of their details. Make sure that you indeed follow through and check the verifiability of those details so that the examinee cannot simply bluff you into believing those details by providing details that actually cannot be verified. So doctors, I hope this helps you. I hope this helps you. You're going to be seeing cases that involve unwitnessed incidences with a delay in reporting. And so you need to have a system and a method for evaluating these cases. And the use of this new verifiability approach in your face-to-face interview with the examinee will quickly help you get to the bottom line as to whether or not an industrial injury occurred or an industrial injury did not occur. And this will help you make a correct determination on AOE, COE probably 99% of the time if you'll simply use this system. So doctors, I hope this helps you. This is another of the recurring themes that you're going to see over and over in the QME evaluation. So this is Dr. Perry Carpenter. It's been my pleasure to be with you here today. Look forward to being with you on our very next session, where we talk about the next in our series of recurring themes that you're going to see 100 times over your career as a qualified medical evaluator. So for now, this is Dr. Perry Carpenter. I'm wishing you best of success in your career as a qualified medical evaluator.